morning, everyone. Minister for Law, Mr. Shanmugam, Attorney General, Mr. Sundaresh Menon, fellow judges and participants in this conference. It gives me a great pleasure to welcome all of you to the 4th Singapore Academy of Law Conference, a conference to review the more significant developments in Singapore legislation and case law during the period 2006 to 2010. I would like to welcome in particular 4 special guests from abroad. Chief Justice James Spiegelman of the Supreme Court of New South Wales, Justice Patricia Bergin, Chief Judge in Equity of the Supreme Court of New South Wales, Justice Datuk Sulong bin Mat Jerai of the Court of Appeal of Malaysia, and Justice Abang Iskandar bin Abang Hashim of the High Court of Malaya. Now, their presence here today reflects a growing interest among common law judiciaries in the Asia-Pacific region, of which there are not too many, to learn about the legal developments in one another's jurisdictions. Not only do we share a common heritage in having the common law as the foundation of our legal systems, but more importantly, our countries share a common future in the peace, progress, and prosperity of this region. So I thank these judges for being here this morning. Now, this conference is held once every 5 years. It has now established itself as the premier conference on Singapore law. The Singapore Academy of Law first held this conference in 1995 to cover the period from 1990 to 1995, when procedural efficiency was the order of the day, as the courts were heavily involved in clearing the backlog of cases. During that period, a more important development for the future of Singapore law, however, was the enactment of the Application of English Law Act in 1992. Now, in spite of its title, the main purpose of the Act was to repeal Section 5 of the Civil Law Act, which essentially provided that the courts had to apply the law as administered by the courts in England in any dispute involving an issue of mercantile law, and also to free Singapore courts from relying on the application of English common law unless it has already been accepted as part of Singapore law. English influence, however, has remained strong. Our courts have not been slow to depart from English decisions since the Act was passed. One example would be the area of calls on performance bonds. In 1995, the Court of Appeal in Bokotra introduced the doctrine of unconscionability from Australian law as the basis for restraining unfair calls on performance bonds, a departure from the English position, which requires fraud to be clearly established. In December 2010, this court held in Gammon that the local position is now too established to be questioned. And recently, the Court of Appeal has followed the approach of the Court of Appeal of New South Wales on the burden of proving foreign law as a fact.